Hello. There are several questions in the community when it comes to the law, especially with immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BWTV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are going to have a very massive discussion on some of the issues of immigration matters that bother you. And they have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community and the Law is brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn, at BWF Solicitors, at BWTV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BWTV. You have your questions. There are answers. So join us, learn, and empower yourself on the program, The Community and the Law. So pick up the phone and dial 0208 493 7345. Or you can send a text 07950 422 780. It's The Community and the Law. My name is Oreku Frimpong, and I am your host. And as another Saturday afternoon, right for all of us, on BWTV, I'm bringing you The Community and the Law. My name is Oreku Frimpong. Welcome to the show. Now, we have always been looking at the visa application, the various ones that we have. One particular one is the spousal visa. In that application, there are conditions that are supposed to be met. My question this afternoon is, how do we meet these conditions, especially the financial requirements? We're going to have lawyer Charles Asma from BWF Solicitors take us through how we can meet the financial requirements through different ways. So I will urge you to ask one person to tell the other and the other telling the other to come on board right on BWTV whilst we bring you The Community and the Law. Community and the Law is brought to you by BWF Solicitors and is right on BWTV, at BWF Solicitors, both on Facebook and YouTube, and at BWTV, both on Facebook and YouTube. Let's get into it together.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340 or our emergency line is 07712 761 884.
Hello, lovely people. It's another wonderful opportunity for us to meet on the community and the law, bringing you a very lively discussion when it comes to the law. And we're doing this by courtesy of BWF Solicitors, our trusted partners when it comes to the law. They are located on the fourth floor of the Anna House, 214 to 218 Tottenham High Road, Seven Sisters in North London. They work Monday to Friday between 9:30 in the morning and 6 p.m. in the evening, and they serve you by giving you sound legal advice when it comes to immigration matters, when it comes to property issues, when it comes to family issues, and the rest of it. Trust BWF Solicitors to give you the best of advice. And they also give us the opportunity to come your way every Saturday afternoon between 4 and 6 p.m. with the community on the law, and we have one of their very renowned and learned lawyers to come over and help us with a discussion. And this afternoon, we're looking at UK spousal visa applications, different ways of meeting the financial requirements. I mentioned earlier on in the introduction that we have various visa types, and when we look at one particular one that we're looking at this afternoon, we are discussing the spousal visa one. Sorry about that, the spousal visa. And there are certain things certain requirements you need to meet. One of them is about money and the finance. How do we meet the threshold that the Home Office set for us? That's what lawyer Charles Asma, our resource person and guest, is going to take us through this afternoon. Once again, my name is Ore Kufripon, and welcome to the show. Welcome to the community and the law. And I believe that those of you who will be joining us live on Facebook and YouTube, you announce your presence and also tell us that you are here, inviting other people and doing that. Even before I could say Jack, Precious Ivy has come on board, and Precious is inviting everybody. She says, I am here. Thank you very much. Yes, Precious, we are also here. And again, let me also sincerely apologize. The last week, due to some technical difficulties, we were not able to come your way. But that said, we have done everything possible to come this afternoon to make sure that we meet as a community and we discuss the law. Different ways of meeting the financial requirements is what is going to be up for discussion this afternoon. Now, those of you who have benefited from the services of BWF Solicitors, you realize that you get quality. And the quality you get is something that we need you to give us feedback on. So we start off one from Gertrude, and she says, I'm extremely grateful to Annie for her outstanding work on my application. From the beginning to the end, she demonstrated exceptional professionalism, deep expertise, and a genuine commitment to achieving the best possible outcome. Thanks to her dedication and attention to detail, as she has said, my application was successful. What truly set Annie apart was her consistent communication and attentiveness throughout the process. Annie kept me well informed at every stage, provided clear explanations, and ensured everything progressed seamlessly. Her proactive approach and supportive manner made a complex process feel straightforward and stress-free. Getry continues to say that I'll try and highly recommend Annie to anyone seeking a knowledgeable, reliable, and compassionate lawyer. Her professionalism and care made all the difference. Thank you, Annie, for your exceptional support and gratitude. Yeah, Annie, we're proud of you. And Gertrude is also very grateful because obviously, as she said, it was a very difficult situation, but you made it so seamlessly easy. Thank you so very much. And we believe that others will also give us such feedback, and we will share it with people. Tiniduma is on board and asking Nanajima, Ritzmami, Tano, Gifty, Siedu Kranchi, Michael Barr, furthermore, all of you are being beckoned to come join us. So when you do join us, please let us know that you are here, and we'll definitely acknowledge you. Now, another feedback is one of video recording, and we want to play that back to you so you know what we are talking about.
Ex-skilled worker dependent switched to 5-year partner route with a new British partner. The skilled worker's ex-partner successfully applied to switch to a new spouse visa as the spouse of a British citizen. Case overview. Our client came to the UK in 2023 with her husband, who was a sponsored skilled worker. Unfortunately, their marriage broke down because she met a new partner. The challenge: divorcing and marrying within a short time. Our client had received a letter from the Home Office stating that her ex-husband had reported that they were separated. She was given 60 days to switch her visa or leave the UK. She was advised that, as they were married in Ghana, she could file for divorce in Ghana. She followed our advice and obtained a court divorce from Ghana. She subsequently entered into a customary marriage in Ghana. Proxies represented her and her new husband. Once the marriage was registered in Ghana, she was ready to make her application without leaving the UK. Our strategy. As a result of the visa cancellation, our client needed to act quickly. We advised her about the lawful way to obtain an overseas divorce under the Family Law Act. Additionally, we ensured that the subsequent marriage complied with the stringent UK laws regarding the validity and genuineness of the relationship. With our vast experience in family and Ghanaian law, we ensured that she had the best chance of success. The outcome: spousal visa, granted within priority processing. The spouse visa was granted within priority processing timeframes, enabling the new couple to move forward with the marriage. This case illustrates how speed and knowledge of family and Ghanaian laws can be effectively leveraged in time-sensitive cases, particularly for dependents facing visa cancellation. Facing complex immigration issues? Contact BWF Solicitors today.
Yes, so BWF Solicitors, we need to contact them. The numbers were on the screen: 0208 493 7340. You can find it at the bottom of your screen. And those of you in Ghana, you can reach out to BWF Solicitors on 055 589 5959 055 589 5959. In emergency situations, call and or text the UK number 004477 127 61884 004477 127 61884. Now, Sandra Fraser says, good evening, all. Thank you for joining us. We are excited to have you on board as we share valuable legal insights and updates. Would love to share a program with you and your friends, so do share, and others will benefit from it. Your support means a lot to us. Let's stay connected and learn together. Oh, I love that. Thank you very much, Sandra Fraser, for doing this for us. And I believe that people will heed to that and kindly share the message. So in the comment section down below, either on Facebook or YouTube, at BWF Solicitors, at BWTV UK, you can make your presence felt. If you have a question to ask the lawyer, you can text that to 07399 208 468, 07399 208 468, or you can leave that in the comment section as people have started doing. So if we see those comments and questions, we'll pick them up. Now, as part of the program, we give you updates as they have come from the Home Office, and BWF Solicitors for the month of November 2025 is giving you some updates as we roll along. This is the first one. Let's look at it. The week prior to today, working in the UK under a student visa. That's something that you need to know. Now, it's saying that international students in the UK on a student visa face strict working hour limitations during term time, which are a condition of the immigration permission. Breaching these conditions can result in severe penalties, including visa revocation, removal from the UK, and re-entry bans. Students studying at degree level or above are permitted to work a maximum of 20 hours per week, defined as a Monday to Sunday period. Students on courses at a degree level below are generally limited to 10 hours per week. It's known that students are allowed to work full-time during official university vacation periods. This is quoted from one of the very interesting cases, Shah and Ano versus the Secretary of State for the Home Department, a 2022 case, England and Wales High Court case 3033. So if you're a student who's come from a different country to the UK to study, what your immigration permission allows you to do is to work during term time 20 hours. So during term time is when school is in session and you go for lectures and all the rest of it. You are allowed to work only 20 hours. But as our Nugget has pointed out, when school is not in session, so say we say that you're on vacation, you can work more than 20 hours. But this is for people who are doing postgraduate degrees and all that. But students at degree level and below are generally limited to work only 10 hours during the week. And they are saying that the consequence of you working more than the 20 hours could be that you will have your visa revoked, you could be removed from the UK, or if they allow you to go scot-free at a point, you can go out of the UK, but coming back, you may have some challenges. Listen, students are allowed to work full-time during official university vacation periods, but they are generally limited to between 10 and 20 hours, depending on the level you are at. Okay, so that said, let's see what my scenario would present. Amabe Brese applied for a graduate route visa after a university degree. Her application was refused. The Home Office alleged that they have information from her previous employers to show that she worked more than 20 hours during term time. Her application, therefore, was refused under paragraph 9.8.3 of the immigration rules. So I'm asking, why did the Home Office refuse the application, although Amma had completed her studies and was applying for a new visa? Could it be that her student visa did not allow her to work more than 20 hours per week during term time? Could it be that it was refused because Amma needs a certificate of sponsorship before she can work for an employer? Or could it also be that because Amma's visa was cancelled for working during term time, they kind of refused it? Think about it. I will come back to you at the tail end of the program and ask you what your answer would be. And I believe that Lawyer Charles Asma at that point will also explain to us which the correct answer was and the reasons behind that. Sandra Fraser has come back again. Thank you very much. It says, good evening, all. Thank you for joining us. We're excited to have you on board. As we share valuable legal insights and updates, we'd love you to share a program with your friends and family. This is her comment on YouTube as well. I think the previous one was on Facebook. So remember, we're live on Facebook and YouTube at BWF Solicitors and at BWTV UK. So before we go into our discussion, let's say thank you to our benefactors, our proud sponsors, BWF Solicitors.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Hello again, and thank you very much. BWF Solicitors, we're so grateful that you gave us the opportunity to really come the way of people, to bring in some level of comfort, educate them, and also empower them to be able to do things for themselves if they so need to. Somebody sent a very interesting question. I'll put that before lawyer when I introduce him. But the person is saying that why can't these people stay in their own country and fix it instead of being a burden to the UK? Well, you know one thing. Maybe the answer I'll give you before the lawyer comes in to answer this is that imagine you are here and your family is back home in Ghana. And you would have to, most of the time, travel back and forth to visit your family. You came here for various reasons. It could be economic, it could be educational, it could be political, it could be any reason, and you are here. And at a point, you know family is very important. So if you need your family to be around you when you have gone to work and come back, you're stressed, you need somebody to talk to, you have contracted marriage or you've married somebody and the person is staying far away from you and the rest of it. Do you feel that you are full, you're complete? Don't you feel that at a point you would want that kind of family relationship and bond to be strengthened? So, I understand your concern. You think that people could stay in their countries, but for various reasons, you may have traveled outside of your country and you want your family around. So, obviously, the need to go through the processes and get your family around you will be quite necessary and important. So, is 99X your concern that people should stay in their country and all the other things? Yes, it could be logical, it could be genuine, but there are reasons for coming to stay in the UK or even to go through certain processes to come to the UK are also very legitimate as well. The UK people, you say, are not responsible for their foreign people whose politicians have failed them. How is it? How is all of the responsibility of the Brits? Obviously, there are Brits who are living in other countries as well. For that, are you going to tell them to go back to their country because they don't need to go and the rest of it? I believe, yes, we could have a discussion and a conversation around that. But yes, thank you for joining us and thank you for staying on here. BWF Solicitors, thank you so much for doing that. But in the meantime, I mentioned earlier on before the break that we have some updates we want to share with you. Let's get into it.
Hello, this is a short video for people who are here as skilled workers and skilled workers dependent. We have identified worrying trends in the community over several months. On average, I receive about 100 calls, and about 70% of those calls relates to this problem that I'm going to talk about. The problem that I've identified is that migrant workers' sponsors are reporting them to the Home Office for their visas to be cancelled. And it could be for so many reasons, but what I've identified is that most of the sponsors are reporting you, the migrants, because they haven't done their jobs properly. As you all know, when somebody sponsors you or a migrant to the UK, they have 5 duties. The most significant ones are the reporting duty, the record-keeping duty, making sure they're compliant with the immigration rules and the UK laws, making sure that they have integrity and they are above complaint. Unfortunately, for some of these sponsored workers, the sponsors have had arrangements in place to support you. And of course, they are aware that you are not turning up to work, which clearly is against the immigration rules. So what they're doing now is that because the Home Office is aware of this problem, that some workers are in the UK and they haven't even reported to their sponsors, and the sponsors are aware of this, the Home Office is taking drastic action in taking the sponsorship licenses from these businesses. These businesses have now become aware that that is a big issue for them, and they think that they can get over it by reporting you to the Home Office, that either you've stopped working for them or you haven't reported for work. Clearly, that's a problem, because if you haven't reported for work, they have a duty to report you. And if the arrangement between you and them is that that is how it's kept, they are now reporting you. So this is to help you to be very cautious if you know that you fall within the category of migrants that I'm going to deal with. The first thing that you must watch out is that the Home Office has the power under the immigration rules, specifically Part 9 of the immigration rules, which relates to cancellation of visas. Paragraph 9.27, for migrants who have failed to work, have failed to report, or have stopped working. When that happens and you are reported, your visa will be cancelled. For sponsors who report this, they also have a duty to report if you're not working. And that is what they've taken advantage of. For migrants who came with their dependents under paragraph 9.24, their visa could be cancelled. Every paragraph I mentioned is discretionary, which means that the Secretary of State may give you 60 days or may not. The problem for some people is that when they are given the 60 days, it means that they need to find a new sponsor or switch to a different visa category. This is what I always advise people. If you're here and you know you haven't reported to work, be mindful that your visa may be cancelled. If you're here and your sponsor is not giving you the full hours, both yourself and the sponsor are in breach of the immigration rules. And therefore, if the Home Office becomes aware, they will cancel your visa. The other issue that I need to raise is that if you know that you're not attending work, you're sponsored but you're not attending work, your visa is going to be cancelled. The sponsors have also become aware that the Home Office is now taking active steps to cancel their sponsorship because they've brought in people, they haven't provided them with work, or even if they provided them with work, they haven't provided them with the hours that they said they were going to provide on the COS. So some sponsors, they think it's smart for them to do to keep their sponsor license, so they are reporting you. Just be aware that if you don't attend work, if you don't report to work, if your sponsor is not giving you work, if your sponsor is not giving you the hours, or if you're here as a dependent and you don't know where your main applicant is, you don't have any contact with them, my advice to you is to make arrangements to switch and move away, because you don't want your visa to be cancelled and only given 60 days. It's a problem that we have identified in the community, and it hurts me so much that our people who have been brought here do not find the necessary support that they need. And when this happens, some of them unfortunately overstay, which means that they are switching to different categories become almost impossible. So my advice to you is that if you know that you're not going to work, you don't have hours to work, your hours is short, your sponsor is not providing you with the necessary support, please move on and find a new sponsor or switch to a family route. If you want to know how to switch, I've done so many videos. Go to our profile, you will find the videos there that will support you and assist you and direct you on how to switch. I hope this helps someone. But if you want to contact us, please, the numbers are going to scroll in a minute. Call any of the numbers and we'll be glad to support you.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Yes, welcome back, and thank you for sticking around and staying on with us on the program, The Community and the Law. Today, we're bringing you a very interesting discussion, and we're looking at meeting financial requirements when you are putting in a spousal visa application. Lawyer Charles Asma from BWF Solicitors is on hand to help us look at that. George, you're welcome on board. Thank you very much for coming. Hello, you say, and I believe that if you have any question, you can text it to our number 07399208468, or you can actually, today that's what we'll be using. If you have any concern or any question for Lawyer Charles Osman, you can call in on 07399208468. Last week we couldn't come up with the program because there were a few technical challenges, but we are trying to resolve all that. So today, the studio line, so to speak, may not be working, but the mobile 07399208468 is available. You can call on it, you can send a text to it, or you can do a voice note and send it over to that number. Remember, we're live at BWF Solicitors Facebook, BWF Solicitors YouTube, BWTV UK, both on Facebook and YouTube. International students in the UK on a student visa face strict working hour limitations during term time, which are obviously a condition of their immigration permission. Breaking these conditions can result in severe penalties, including visa revocation, removal from the UK, and re-entry bans. Students studying at degree level or above are, by the law and by their visa conditions, permitted to work a maximum of 20 hours per week. And that is defined as Monday, Tuesday, Wednesday, Thursday, Friday, Saturday, and Sunday. 20 hours. Okay. Now, students on courses at degree level below are generally limited to 10 hours. So let's say secondary A level, before you do your degree, and you want to work as an international student, you could be allowed to work for just about 10 hours. But from degree level up, you are allowed to work 20 hours per week. Students, however, are allowed to work full-time during official university vacation periods. So let's say that your semester runs between September, August, July. So say from June to September or June to the end of August. Within that period, you are allowed to work only 20 hours per week. But between September and say probably the beginning of another semester, you could have 6 weeks, 8 weeks, and you have a job, you can do more than that. But if you do not follow these and say the Home Office goes ahead to do some checks and they realize that you were working more than the 20 hours, certain things could happen to you. You could have your visa revoked. You could be removed from the UK. Or if you're not made to face either of these, you could have a ban on you to say that you can't enter the UK for a certain number of time or a certain number of months, years, whatever. So remember that you are allowed to work only 20 hours per week if you're a student. It could be 10 hours if you are below the degree level or up to the degree level. Beyond that, yes, you'll be allowed to work for more than 10 hours, which will be 20 hours maximum. Shah and Ano had a case and they had to battle it out with the Secretary of State for the Home Department. This happened in 2022. England and Wales High Court case 3033, and this has come out of that. And BWF solicitors have found it necessary to really bring this out for all of us to be aware of so that we don't fall foul of the law. So then I wanted to ask you this question. Let's look at it. Now, there was this friend of mine, Ama Bebrese. Ama Bebrese applied for a graduate route visa after a university degree. See, she's come here, she's worked, she's attended school, has had her first degree. Then said, okay, well, I want to stay on. So then the graduate route visa, the extension is done. She wants to have further education, and the application was refused. The Home Office alleged that they have information from her previous employers to show that she worked more than 20 hours during that time. Her application, therefore, was refused under paragraph 9.8.3 of the immigration rules. So I asked myself the question, why did the Home Office refuse the application, although Amma had completed her studies and was applying for a new visa? I've given you three options, and I want to find out if you could give me the correct one. One is the Home Office refused the application because the student visa, did not allow her to work more than 20 hours per week during term time. It was refused because Amma needs a certificate of sponsorship before she can work for an employer. Um, Remember that she's completed one and was making a further application. And the third option, which could be an option for you to choose to answer the question, was because Amma's visa was cancelled for working during term time. Which of them is correct? I believe that you would compare this situation or scenario to the nugget I gave you, and then you will give me an answer. Maybe I would want to read that again. That the situation where people work in the UK under a student visa has some conditions around it. International students in the UK on the student visa face strict working hour limitations during term time, which are a condition of the immigration permission, as I said. Breaching these conditions can result in severe penalties, including visa revocation, removal from the UK, and re-entry bans. Students studying at degree level or above are permitted to work a maximum of 20 hours per week, defined as a Monday to Sunday period. Students on courses at degree level below are generally limited to 10 hours. Students are allowed to work full time during official university vacation periods. And as I said, I quoted this from the England and Wales High Court case 3033, which was determined in 2022. So think of the question. Try to give me an answer. You can put that in the comment section down below at Facebook, on Facebook at BWF Solicitors, at BWTV UK, on YouTube at BWF Solicitors, and at BWTV UK. Or you can send it via text to 07399 208 468. 07399 208 468. As I speak, there are a few texts that have come. There's one with a question that we'll put to Lawyer Charles Asma in a jiffy. And then if you would want to put that in the comment section as well, Lawyer Asma, as I said, is ready for us. So without much ado, I will show you again our social media handles. Then we will get into our discussion. UK spousal visa applications, different ways of meeting the financial requirements. It's live on BWTV, and the program is The Community and the Law.
Gonna cut off.
Okay, live on TV, BWTV, and The Community and the Law is the program. I mentioned that Lawyer Charles Asma from BWF Solicitors is with us today, and we bringing you the discussion on how to meet the financial requirements when we putting in a spousal application. Lawyer Asma, visa types, yes. We're looking at one of those, that is a spousal visa. what does that get us to do? If we say spousal visa application, what type of application are we looking at? If you would mind, or you wouldn't mind, so to speak, telling us what it is. Yeah,
Types
yeah.
of
Okay. Yeah.
we have different types of visas. This
Mm-hmm.
conversation is actually looking at spousal visa applications. And
Mm.
spousal visa application, we are looking at applying to enter the UK to join your husband or wife, or applying to remain in the UK if you're already here with your husband and wife, to remain with them in the UK. And
Okay.
this is what we call spousal application under Appendix FM. It's Appendix FM because it does not apply the EU provisions under Appendix EU. It's purely immigration rule provision for partners or spouses who want to remain in the UK or who want to enter the UK to join their spouses or partners. And of course, the definition is clear under appendix relationship with a partner, the relevant paragraph 5.2, 6.2, they talk about the nature of partnership, either married to the person or being in a relationship with the person for 2 years. And the relationship, if it's not marriage, is akin to marriage, whether living together or not. If it is marriage, then there should be a verifiable evidence of marriage that has followed through the marital processes or marriage laws of the relevant country or the particular country involved. And so it's clear that the person is married, the relationship evidence. The other evidence is what we call financial evidence. And the financial evidence is important because you have to prove that you meet the financial requirement. You meet the financial requirement. And under the financial requirement, obviously, we know that before the rules changed, if you joined your husband or wife before the rules changed, you could then show 18,600. That is no child. If there are children involved, then you show 3,400 for the first child and 2,800 for any other child involved. And if you are renewing based on 18,600, you continue 18,600. The rules changed and the money or the financial threshold was increased from 18,600 to 29,000. And so we are talking about 29,000 as a spouse to be able to apply to remain in the UK or to join your spouse if you are abroad. So
Now,
how do you...
sorry for interrupting, but if you say 29,000, 29,000 as in what? In a month, a year? And is
Oh,
that
that's a
before
good...
tax? Is that before tax or when tax has been taken away?
Right. Yeah, good point. So we are going to go into the specifics. So 29,000 first off in pounds, and 29,000 per annum, and
Okay.
29,000 before tax. So that's the
Okay.
gross income for
Okay.
somebody who works. So we're looking at different ways of achieving or meeting this. And we are then going to look at people who are self-employed. How does it also apply or work for them?
Okay. All right. All right. Thank you for that clarification. So, those of you who have just joined us, as I said, we're going to look at that discussion and looking at how we can meet that requirement. We're talking about from 18,600 to 29,000. And if there are children, 3,400 for the first child and others for the other children as well. That to you may look and sound as a very huge amount. How do you meet that? If you are self-employed, how do you also calculate this 29,000 before tax, as it were? So, first of all, let me again say thank you very much to Lawyer Charles Asma for agreeing to use this Saturday afternoon to help us on this one. So if you have any question, put them in the comment section down below, either on Facebook or YouTube at BWF Solicitors and at BWTV UK. Or you can send a text to 07399 208
468. Get your notepads ready. Call people, like, share the page, and also announce your presence because we're going directly into the discussion. How do we meet these requirements, lawyers man?
Right. Thank you very much. So I will request producer, if you are available, and if you get the resource, which is the financial requirement for not this one. Yeah. Okay. So we'll look at this briefly, but there's another one that the PDF document that talks about Appendix FM minimum income requirement or threshold. So for the 29,000, you are working. So what normally happens is that we check your income for the year before tax.
Mm-hmm.
You can add your P60, but the key thing is your pay slips for 6 months. And if application is being made today, for example, we calculate up to today backwards for 6 months. So we've just entered November. What it means is that we look at October backwards. So October, September, August, July, June, May. So for somebody who's applying to remain in the UK or for the spouse to join them in from abroad, they have to
Mm-hmm.
show that financial requirement of that amount. And if you go back, producer, just go back a bit, it tells you that this is 2025 revised minimum income requirement. Before we go into delve into the document itself, we are looking at what we know already. So most people will say, okay, I have the 29,000. What do I use to prove that? Or what do I have to provide to show? So we
Okay.
need your 6 months income pay slips, 6 month pay slips. And the
Mm-hmm.
money should be linked to the net that came into your account. So bank statement.
Okay.
So 6 months pay slips, 6 months bank statement.
Right.
How do we know that the bank statement is corresponding to the pay slips? So what you usually do is to map the money on the pay slip, which is net, against the money in the bank statement, which is the payment you received for that month. The
Okay.
caseworker is not looking at the actual money in the bank account, but actually the gross. Because even though you have the net in your bank account, it is the gross which is used to determine whether you meet the 29,000 or not. So that is sort of a good news, because sometimes your gross is high because of national insurance tax and because of income tax and other deductions, your net will be low. So if your net is not up to 29 and your gross is more up to 29 or more than 29, you are okay. So that's the
Okay.
first thing.
Okay.
And this month's pay slips. So what about if I'm doing different jobs? We put all together. So job
Okay.
one, job two, job three, put together. For who? For the applicant and for the spouse or the sponsor. Both of them, any of them. What if not enough for each of them? We combine. I don't know if you are getting the permutation.
If you say that we're looking at both of them, let's say my spouse is outside of the UK and earns income in a different currency, and the person making the application here in the UK earns more than the 29,000. Do we have to necessarily include the person outside of the UK's income as well
In this case, the person will have to convert it to pounds,
to add to that?
to be able to. But most people applying to join their spouses, it's often the case that the spouse in the UK is able to use their income to show or to meet that threshold.
Okay.
So the person in the UK may be working, and that's why we said that both. But if the one abroad is not able to, because even if you convert, it's not enough, then obviously will fall on the one in the UK. The
Okay.
one in the UK may be doing different jobs, so combined income from the various jobs
Okay.
will lead to that or will help us to establish the threshold of 29,000. What if there are children involved? Before you needed to add to make up for the children. Now you don't have to add to make up for the children.
Okay.
The other good news with the new threshold basis is that if, for example, your partner who is in the UK, you are joining them from abroad, or your partner in the UK, if you're already here, you might be working and your partner is working, so it's fine. Or your partner may even be on pension, so it's only you. So I'm going to look at a couple of examples, practical examples that we've had in recent times. So the general position is that if you have employment and you can tell that this employment is permanent and this employment is starting now or soon or has just started, even though you have not received your income yet or your pay, your first pay, you know how much you are going to get. So we can argue on the basis that you have employment, you know how much you are going to get. This is permanent employment. And therefore, even though what you have in the last 6 months is not up to 29, with this new one, we can add it.
Okay.
So that is another way of um, checking whether the requirement can be met in terms of the finance. Now, somebody may be self-employed. Self-employed. With self-employed, you know that you don't have pay slips. You don't have even the money coming in will be in and out, drips and drops. What it means is that we have to check whether one, you are registered as self-employed. Here we are not talking about a limited liability company. It doesn't matter whether you are running, because if you are running a limited liability company, then on the basis of the law, you are different from the company, because within the Companies Act 2006, if you are operating a company, the company will have to be different from the owner. So you can't say that I'm using the bank statement and the financial records of the company to bring my spouse or to sponsor my spouse. It is your company, but you are different from the company. What it means is that if you are running a company, then you may be there as a director. And then as a director, you have to file returns as a director under what we call P11D. So P11D is a form that you as a director, you use to declare your income as a director, which you will use to file self-assessment in your capacity as an individual director.
So, lawyer,
So,
as a director of a company, for instance, as you're saying, different from the individual, now they would want to declare that they earn 29,000, as we are saying. Do they have to show that they work for the company, or as a director they receive some dividends, or if they are executive directors they're working for the day-to-day running of their business, they will have to show their pay slips as well, or something that shows that they are being paid?
so as a director, as I said, there is a requirement for directors. If you are a
Mhm.
director, you are receiving pay, that means you are what we call executive director. As an executive director, you are working and at the same time directing the affairs of the business. So you are an employee, so to speak. And so if
Okay.
you're an employee, you can use your pay slips to determine that. So you
Okay.
don't really have to say that you are self-employed.
Okay.
But if you're a director, for example, non-executive director, or you are a director, but it's such that because this is a one-man business, you don't really pay yourself as a worker on monthly payroll basis, but
Mhm.
you have director allowance and emolument and so on and so forth, then
Okay.
you have to declare those ones under Form P11D for directors. And you have
Okay.
to, HMRC will give you unique tax reference number to be able to file your self-assessment, to be able to declare that. So that is for individuals who are running companies, limited liability companies, private limited liability companies, and themselves are directors. And they will say, lawyer, I have a company, I'm self-employed. I usually tell them that if you have a company, please, we cannot rely on the company's affairs to determine your personal business of bringing or
Okay.
sponsoring your wife or husband. So what is the learning here? If you are self-employed and want to rely on that to bring your wife or to sponsor your husband or wife, more often than not, if you are running a sole proprietorship, you're only dealing with HMRC. But if you are running a company, then in your capacity as a director, you have to prepare what we call director's threshold in terms of money received by the director, and get HMRC to give you opportunity to file your returns.
Okay. Right. So then we have looked at individuals, people who work, how to combine the incomes to meet the threshold. You have mentioned that we need our pay slips or something to determine 6 months of earnings. And you have also mentioned that we have to calculate backwards. So, for instance, we're now in November, so we'll be looking at October, looking at September, and August down the line. How do I, as an individual, put together these ones, and what do I indicate, say, on the pay slips? Do I have to circle what comes in as part of my what is showing on my pay slip, or what? Do I have to put the pay slip and the bank statement together? What do I do?
Thank you very much. Producer, please, if you are available, kindly share the resource with us. The one that you showed us, the PDF version of the financial requirements.
Okay.
Right. So, Brakoku, this is version 12, and it says for armed forces, appendix armed forces, and also appendix FM. Our focus is FM, but also if your wife or husband is in the armed forces, this will be relevant. So let's go down the content page. And just so we know, when was this published, please?
It says page 1 to 78, published for Home Office staff on the 12th of March, 2025.
So it's relevant. We go down to the content, calculating minimum income, financial requirement for. So it says who needs to meet the financial requirement. And we know that appendix FM, you meet the financial requirement if you are joining your husband or wife. Who needs to meet your financial requirement? Again, appendix FM, if you are joining your husband or wife and the person is in the armed forces. Now the calculation. So financial requirement, page 11. So producer, take us to page 11. Right.
So, calculating the minimum income requirement. Following the changes to the minimum income requirement MIR of 11th of April 2024, different thresholds apply to applicants depending on the date the current application was submitted. When the applicant first successfully applied to the route, and whether they are applying under Appendix FM or Appendix HM Armed Forces. In summary, under Appendix FM, the thresholds must be applied as follows. Those who apply on or after 11th of April 2024, who are new to the 5-year partner, fiancé or fiancée, or proposed civil partner routes, or who are applying for permission to stay with a new partner, must meet the threshold of £29,000.
So the point is that, Brakoku, if you are applying as a spouse in the UK or outside the UK, and your application is made on, and it's actually on or after. In other words, from 10th of April 2024, everybody making application as a spouse must show 29,000 from 10th April 2024. And we are in November 2025. So this will apply to such a person. And again, it's and for the 5-year route. If you are applying and the application is assessed under the 10-year route, you don't have to show financial requirements. So that is a takeaway. So point two, please go to point 2.
So those who apply on or after 11th of April 2024, who are already within the 5-year partner, fiancé or fiancée, or proposed civil partner routes, and are applying for permission to stay with the same partner for which they were last granted permission, benefit from transitional arrangements. That is, they must meet the lower threshold of 18,600 plus the child component capped at the maximum of 29,000. And
right. So Brakoku, I think here there is a learning point. Somebody may have come to the UK as your partner, okay, as your partner.
Mm-hmm.
And because at the time it was before 10th of April 2024, and the person had to show 18,600. And
Yeah.
again, the person came with children. The first child 3,800, and the second child 2,400. So give and take, the person had to show about 24 to 26,000. So this
Mm-hmm.
is your partner with two children, and these children are your stepchildren because they belong to the woman. Now, whilst in the UK, for whatever reason,
Mm-hmm.
um, the relationship between you and this lady is breaks down, and for whatever reason, the lady begins another relationship with um, uh, another man, which is me in that case. We want to make
Mm.
it practical and relevant. So I'm now the partner. And so the question is, will this person use 18,600 because they were here before, or because now they have transferred to a new partner, they are going to use 29,000? Does that make sense?
Yes, yeah.
In this
And
case, it says
to
that,
answer that, I'll behave like a lawyer. To say that, as the rules say in Appendix FM.2, on the threshold, it says those who apply on or after that period and are applying permission to stay with the same partner. So in that case, if it was the same partner, it would be capped at 29,000, starting from the threshold of 18,600. But if it's a different partner, then it doesn't apply.
good. In this case, if my salary is 28,000 and nothing else, and this woman has not been working since the person came, and just relying on you then, and now they are with me, I'm not working, so they also not working, 28,000. Would they be able to extend to renew under me?
Since they are with a new partner, they don't meet the threshold, so no.
As simple as that. Good.
Okay.
Now we go to point 3.
Now, point three says those who apply before 11th of April 2024 must meet the previous threshold of 18,600 plus the child component where relevant. There is no cap in place for this cohort.
So those people who were before the change came, before the revolution, they will not have to show anything. But if you entered or you came with the revolution, then the 29,000 will follow you. Now, the last point.
The last point says a child applying under Appendix FM must meet the same threshold as the parent they are applying or accompany or join, regardless of the date of the child's application.
So for the children, it doesn't really matter because they were at the time they were applying to join their father or mother, they had to show what we call the maintenance threshold. Because for children, it is not 29,000, it's maintenance threshold. And with
Mhm.
that, there's no semantic about 18,600 or 29,000. It's just a standard maintenance for children. But because the discussion is spousal, we are sticking to spouses. Right.
Okay. All right.
Now, producer, let's move on to the following table.
Yeah, so the table, as you can see on your screen, supports decision makers to assess whether someone who is applying under Appendix FM to renew their permission as a partner on or after the 11th of April 2024 falls within the transitional arrangement. So let's look at the table, if you may.
Yes.
There are columns in there, and it's asking questions. The columns are asking questions, so to speak. Did the applicant first apply as a partner, fiancé, or proposed civil partner before 11th of April 2024? If the answer is yes, the answer could have been known. Laura.
Yes. So, did the applicant first apply
As
before
a
the
partner.
change?
Mhm.
If the answer is no, then 29,000 will apply. If the answer is yes, then 18,000 plus children component will apply. That's why if you go to the last column, minimum income, yes or no, you have
That's
to
our
choose
finance. Okay,
29
so
or
if you
18,600.
answered yes to all the questions, then it means that the minimum income requirement applies. This is 18,600 plus children component, and it's capped at £29,000.
Very good.
Okay.
Very good. Yes. So because of time, we just jump, scroll down, please, for me. for us. Yes, then here again, yes or no, yes or no, yes or no. But the key thing is that we are not going to worry ourselves about the yes or no's. The main thing is that if you are applying from 11th of April 2024, it's 29,000. If you applied before and you are renewing, it's 18,600. If you applied before and you are renewing with a new husband, 29,000. Does that make sense?
You said new husband. It could be a wife as well.
And okay, new partner. I agree with
Okay.
you. I agree with you. New
Mhm.
partner. New
Right.
partner. Yes.
Okay.
Good. Now let's come to armed forces quickly. In summary,
So,
under armed forces.
in summary, under Appendix HM Armed Forces, the thresholds must be applied as follows, and there are two of them. Those who apply for the first time as a partner, including as a fiancé or fiancée, or proposed civil partner, or child of HM Armed Forces or an HM Armed Forces service leaver on or after the 11th of April 2024 must meet the 23,496 threshold.
Let's pause here. So, Brakweku, whenever you see HM armed forces, just say in the army. That's what
Okay,
most people know.
okay,
Yeah.
okay.
So if you
Oh,
are your partner or if your partner is in the army or a serviceman or woman, instead of 29, you need 23,496. Let's make it simple. That's about what? 23,500, isn't it?
500, yes.
Good. For simplicity, 23,000. So you can see that armed forces have privileges over civilians.
Mm,
Right.
the,
Then we'll
the,
go
the,
to
the defenders.
we'll go to the next one, the second threshold.
And the second threshold says those who have already applied for and are being granted or have been granted entry clearance or have permission as a partner, including as fiancé or proposed civil partner or child under Appendix Armed Forces before the 11th of April 2024, benefit from transitional arrangements. They must meet the lower threshold of 18,600 plus the child component. The threshold and child component is capped at 23,496 to avoid the transitional arrangements being disadvantageous in comparison to the new flat rate MIR.
Yeah, so for those armed forces spouses who applied before 11th April 2024 rules changed or the revolution period, what it simply means is that 18,600, but to avoid the lengthy calculations regarding the children component, all is capped at 23,500 pounds. So
Mhm.
for armed forces, whether before or after, is 23,500,
Okay,
with or without children. If
without children.
obviously with children, but if without children and before, that would have been 18,600 for simplicity. Right.
Okay,
Now, we are moving on. So we've touched armed forces, we've touched civilians, we've touched those working, those not working, but we come to what specific document we need. And now it says, unless you are exempted, you must show 29,000 if you are applying under 5-year route. What if you are applying under 10-year route as a parent? That means there is a child involved. In that case, EX1 will apply, which is the exceptional circumstance EX1 provision paragraph EX1 of Appendix FM, which means
mhm.
that the person may not meet all the requirements, including in finance, and so cannot be put under the 5-year route, and the person will go under 10. With those under 10, you don't worry about money. Even if you have £1, you are okay.
Okay.
Right, we'll move on. So let's go down. Please, producer, scroll down for us. So the transitional arrangement, we've already explained up there with this. So we are not going to go into the transitions. But let's
Okay.
read this. Those who have permission on the 10-year route to settlement.
So those who have permission on a 10-year route to settlement, when they make the application, are unable to benefit from the transitional arrangement.
I
What
think
does that
we
mean?
I think we said that, didn't we?
Mhm.
We said that those on the 10-year route don't have to worry about money because they are put on a 10-year route because they didn't meet the threshold under the 5-year route. Right.
Okay. Okay.
So money is not a problem for them. In that case, they
Okay.
don't have to bother about that financial requirement. Let's scroll down, please. Producer, kindly, yeah. Right. So again, children, We know that children 18,600 plus 3,800, 22,400. So one child, two children, three children, four children or more is that. So you can see that if you are applying and you have 10 children or one or 5 children, it's 29,000, regardless of the number
29,000.
of children,
Okay.
29,000 at the moment. All
Okay.
right. But
So
if
that's what it means to say that it is capped at 29,000.
very good,
So when
maximum
you pay up to
29,000.
29,000, even if you have 10 more children,
Exactly.
that's only what you have to show.
Yes. Somebody will say, "Oh, lawyer, that means it's good to have more children if you are applying under these immigration rules." Yes, but after the application, you have to feed them.
Obviously.
All
Obviously.
right. So there's no incentive per se. All right.
Mhm.
Okay. Now we move on to the next one. Financial requirement for children applying on any date under. So with children, because the conversation is about spouses, we are not going to bother much about children. So please, let's go to the next.
Okay.
Evidence. So we are looking at the evidential burden or the evidential pieces. So applications before 11, evidence to be provided. We know that you have to show the pay slips and so on and so forth. But scroll down, let's go to specific. Please go down for us. Please go down. Down, further down, please. Okay. All right. So the first applications on or after 11th of April 2024 as the partner or child of a member of armed forces. As we said, armed forces have privileges, and theirs is capped at 23,500. And
Right.
non-armed forces, they have to show the usual 29,000 or 18,600 if before the date. Now we go and look at the evidential bit. But what about people who cannot meet the salary in terms of wages or self-employment? Can they rely on savings? So if you go back to the table, please, if you go back to the content, producer, back to the content. Right. So it tells, so scroll down for us. Okay, so operating principles, meeting financial threshold, and that's 17. So page 17, please. Take us to page 17. Right. So meeting the financial threshold, and that is what we call specified evidence. So the caseworker will look at specified evidence for the people or the individual applicant. So, Ragoku, if you take us through this briefly.
So it says under Appendix FM, Appendix HM, that is those in the army, and Appendix FMSE, the applicant must meet one, the level of the financial requirement applicable to the application, the requirements specified as to the permitted sources of income or savings.
So you see, it says income or savings. So the source of income or savings. So there are people who may be relying on income. They have to provide evidence of the income. Others may be relying on savings. They have to provide source of the savings. And the next one is the timing.
And the time periods and permitted combinations of sources applicable to each permitted source relied upon. And then the evidence required for each permitted source relied upon. Does this mean that, the first point says permitted sources of income or savings? In legal terms, when we say or, then it means one or the other. But then
Yes.
it goes on to talk about combinations of sources applicable. Does it then mean that even though it could be one or the other, you can put them together?
Yeah, so the combination of income, for example, will be that your income from job A, your income from job B. Somebody may be working for 4 months, last 4 months, and the job or they lost the job or for whatever reason they left and moved to another employer. So that's
Right.
job B, isn't it?
Mm-hmm.
Or the new employer. So how can we look at where they were before and add to where they are now? That's what this is saying, the combination of those sources of income.
Okay.
So old employers or old income from employment, new income from employment, if we say old, still within 6 months, but different employers, and some of the employers you have moved on or you are no longer working for them. But those income that you had within the last 1 year, can you put them together for such purpose? The answer is yes, those sources.
Okay. So if it's within the period that the Home Office is looking at, the previous 6 months or the past 6 months, so to speak, that's fine. Even though you may not be working, it is income that we can consider to have been earned or will be earned.
Yes. So the key thing is the reason why we talk about 6 months is that we'll focus on 6 months, but we'll multiply by two to get the year.
Okay.
So if you have, let's say, 4 months, and if we multiply by two, it's only going to give us 8 months.
Eight
Then we
months.
cannot talk about a year, especially where the employer is not, or where the job is still not running for you or ongoing. So there are specific combinations where somebody may be working previously, they stopped, started new job. They were earning some money, but the current job may not meet the threshold requirement. Can we go back and see where they were before? You see, the whole policy concept for this financial threshold is for people not to rely unduly on public funds.
Okay.
So if I
Okay.
can show that with all these combinations, I will be okay, I will be self-reliant, then the rules say that a person should be permitted to enter the UK or to remain in the UK. All right, please continue.
There's an interesting question that's crossed my mind. The 29,000 threshold that we're looking at, does it mean that the person, if earning 29,000, will be able to at least support one person without them relying on public funds?
That's the presumption that after, and mind you, the 29,000 is gross. And if you do
Mhm.
the calculation, at the moment, gross 29,000 falls within the 20% tax bracket, the lower threshold.
Mhm.
So, and you have your personal allowance of you have personal allowance of 12,500 and something. So let's keep it simple. 12,500. If you take 12,500 from 29,000, if it's 12 and you took this from that 29 from 12 from 29 would have been 17,000 minus
17,000.
500, 16,500. 16,500 tax of 20%. 16 times 2 is 32, so 3,200.
320. Yeah,
So you
3,000.
can see that 3,200 tax from 29,000, you still have enough of about 26,000 to be able to survive on. 26,000 divided by 12, if it's 24, that would be 2,000. You are left with 48. So give and take, you still have enough, about 2,500 to be able to, or about 2,200 to be able to survive a month. And so 29 should be okay for you. And that's why they don't want to go into the net. Because once you do all the calculations and NI and all that, you should still have something to survive after your rent, after your council tax, and so on and so forth.
Okay. Well, we're looking at how we can meet or different ways of getting that sorted out. You've shown us what the law says, what the thresholds are, and the income combinations that we can have. We're looking at income that is earned monthly from employment or self-employment, where it is that you declare all these profit and losses and you calculate all those things. Then the question then is, um, when I put in the application and show the evidences, would it then become a matter of course and the tick box to say, well, I meet that, so I'm okay?
Yeah, just the algorithm. If A is B, then C holds. Simple as that. And that
Okay.
is where we are able to challenge if there is a refusal, because the rules are clear that if the eligibility requirements are met for this application for spouse, the application must be granted where there is no suitability issue. So if there's no suitability issue, and we are just talking about the requirement, relationship requirement, English language requirement, um, financial requirement, accommodation, and finance is the issue, and again, we've ticked the box for finance, then will you refuse me if it's all tick?
Well, I've satisfied all that, so
That's it.
obviously there's
Whether
no
you are
problem.
happy or not, it's a tick box.
Okay.
So you can see that that is when you are working with these numbers, you just have to be meticulous. There is a fundamental mistake that some people make, especially those who are self-employed. And I'll touch briefly on that. The key thing is that the money, whether self-employed or um, employment, must
Mhm.
be in the name of the person concerned. So if it's the applicant's income, the applicant name. If it's the sponsor's income, sponsor's name. The sponsor, you can use the sponsor's income to support the applicant. You can use the applicant income to support the applicant, him or herself. And you can use
Mhm.
combination of both. But the
Okay.
names must be clear. So you cannot use somebody who is not a partner, in other words, somebody who is not an applicant or sponsor. You cannot use pay slips of somebody who is not an applicant or sponsor to say that I have this to support my application. That will not work.
Then the question then is, if I have, for instance, 28,000, but I need 29. I don't have any savings to support that. But I'll bring up two scenarios. I have a family member or a friend who has enough savings to help me meet the threshold. Or I have potential employment income that in the next 2, 3, 4 months I will be earning. Can I use any of these or a combination of them?
Okay. So the key thing is, you said I have a family member. It's not about the family member should be a child or a partner or
Okay.
yourself.
Okay.
So if it's not your money, then it should be your partner's money. If it's not your partner's income, it should be your child's income. Otherwise, no, cannot be other family members or friends. But
For the spousal visa specifically.
yeah, for the spousal visa, it cannot be any other family member or friend.
Okay.
But you also touch something which is fundamental, and I raised that point, what we call potential income.
Hmm.
The rules make provision for such potential incomes. There's one application that I did for a client. It's been successful. The lady came with a child, and so the threshold was 22,400
Hmm.
for the child and the lady.
Right.
Then she met the requirement because the guy was working, earning enough. Then, upon arrival in the UK, the guy was receiving benefit. The lady was working part time. Benefit, how much both of you make will affect the income, the benefit. So the man cut his earning. The lady was cutting the job hours, and they were earning less but obtaining benefit to support themselves.
Hmm.
At the time of application, I told them that your income is not up to 22,400 for you and your child because you are earning 14,000. Your husband is earning it was about 6,000. So give and take it was about 20,000, right? So it wasn't up to 22,400. So we're stuck. So the guy thankfully had applied and obtained, has been working for a new employer. He's been paid twice. But this is a potential employment. He's already started anyway. So what I did is to prepare what is there already. And even some of the 14,000 for the lady, some of the job had already been taken over by other employers. And she's been moved to another contract with less pay. So what I did was to put together the original threshold. And I said that my client's combined income with a spouse is about 20,000. This is below the threshold of 22,400 before because its application was made before the change. However, The spouse has obtained, has gotten new job, has been working for the past 2 months. This is the pay slip. The income per month is about 1,200, and therefore, income for the year for the partner, that is take home, is 1,200, and the gross was about 1,005 thereabout. So putting all together, I was able to argue that if the take home is 1,200, for example, and the gross is 1,005, then 12 months, which is 15 by 10, that's 15,000 plus 3,000, 18,000. So the partner has 18,000 potential income ongoing, even though not up to 6 months. The lady also has something, and before it was 20,000. So put together, it's about 38,000 as a family
Which goes
income,
beyond the threshold.
household income, and this is more than the required threshold. So I was able to pull all the pieces together. That is why the rules say combination of acceptable sources.
Okay. All right. Well, if you just joined us, we're live on BW TV, and the program is The Community and the Law. This afternoon, we're looking at UK spousal visa and various ways of meeting the financial requirements. Lawyers taking us through what the guidance is for the caseworkers to use. He's explained the sources of income, the acceptable ones, the different levels of combinations, and those who are on the 5-year route, what you are to expect and see and also meet. Those who are on 10-year route, you don't have anything to worry about. Those in the armed forces, your threshold is also lower. There have been changes, and we have touched on all those. So I know you may have a question or two. You can put them in comment section down below on Facebook at BWF Solicitors, and on YouTube at BWF Solicitors as well, BWTV, both on Facebook and YouTube. Or you can send a text to 0739920848. You can also call that number, at least for today, if you have any question or concern to send to the lawyer. There's a very interesting question that even came in before we started our discussion. I know you have seen it. Is 99X says that why can't these people stay in their own country and fix it instead of being a burden to the UK? The UK people are not responsible for foreign people whose politicians have failed them. How is it all the responsibility of the Britons?
Yes. Well, I mean, we all have perspectives, and this is our viewers' perspective. I usually appeal to such people to impress upon their MPs to get the laws changed. But until the laws are changed, this will continue. And as a matter of fact, the world has become a global village, and most countries rely on nationals of other countries to be able to promote their economic progress and economic activities. And Britain is one of such countries that believes in international cooperation, international harmony, and free movement of people, goods, and services. And so, insofar as immigration is paramount to human progress and national development, these laws will continue to prevail. They haven't been changed yet. As a matter of fact, new ones keep coming. And so my brother or my sister who is expressing this view, until they are changed, there's nothing that anybody can do.
Well, keep yours coming through 0739920848. Want to say thank you to BWF Solicitors for helping us do this. You can call them on 0208 493 7340 or 077 884. Lawyer Charles Asma is here if you really want to get through to him. I am going to put his number on the screen as well for you to contact Lawyer Charles Asma 07947 636037 07947 BWF Solicitors are trusted partners when it comes to the law. Yes, we had a question on the screen. Laura, if you permit me, we will quickly go on to that.
I'm sorry, when we finish that question, let's go to page 26 to show something.
Well, then let's do the page 26 before we come to the
Okay,
question.
yeah. Producer, please.
or
exactly.
if you
Producer,
look
let's look at page 26, please. Because we are looking at different ways. So page 26, maybe you select from the top, from the content page. Page 26. It talks about categories. 26.
Okay, so source of
Yes,
income permitted
sources of
in respect to
income,
the.
sources of income requirement. Yes, sources of income not permitted, and salaries and non-salaries. Yeah. So let's look at this one.
Okay, so where the applicant has to meet the minimum income requirement, the financial requirement can generally be met in the following 5 ways. So we're looking at one, income from salaried or non-salaried employment of the partner and or the applicant if they are in the UK with permission to work. This is referred to as category A or category B,
Okay.
depending on the employment history.
Right. So category A, category B are the standard, what we call the organic threshold, organic source, income, and
Mhm.
self-employment source. So
Okay.
here you have to show your pay slips, or you have to show your self-assessment document, accountant report, what we call Form SA 302, showing your tax calculation and so on and so forth for self-employed. Then we have category C. Category C, please, non-employment sources. Please go there.
Yeah, so it says non-employment income, for example, income from property rental or dividends from shares. This is referred to at category C, as Laura has
Yeah,
explained.
so somebody will say, wow, that's great. So even if I'm running a property in a rental business, I will be able to rely on that. Yes, under category C. What if I'm a shareholder receiving dividends from companies or from my shares? Can I? Yes,
Mhm.
you can, under category C. Then we
Okay.
go to category D, savings. What about people who have savings but
Mhm.
not regular income? Yes, if it's more than 16,000, it says more than 16,000. That means if you have 16,001 pounds, it's more.
Okay.
So more than 16,000 held for at least 6 months under control of the partner or the sponsor or both of them. And that's the
Right.
key thing, under control. How do you prove that this is your savings? It must be your name, isn't it?
Obviously, yes.
What if it's a combined savings of a family, you and your siblings? Can you use it?
It says combined, yes.
No, you and your
No,
siblings.
oh, okay, you and your siblings, but it's not in your name alone, so you can't.
Yeah, it's not under your control. It's in your
So it's
name,
not for you
but
alone.
not
Yeah.
under your
Yeah.
control. You need
Okay.
somebody's permission, so you can't. And here we are talking about what we call joint account holders.
Mm-hmm.
So joint account holder, you had savings with your ex-partner and you have moved on to a new partner. Can you use it? No, it's not
No,
under
it's
your
not
sole
under your
control.
control. Yes.
So that's the um, point for savings. 16,000 and more. As for more, how much more? It doesn't matter. At least 16,000. And it has to be, it says above. And because the rule says above, it's always important that you go more than 16,000. Does that make sense?
Yes.
Because if you bring 16,000, they will say this is not above.
Mm-hmm.
So it has to be 16,001 pounds at least, which is above
Okay.
16.
Okay.
Right.
I think the next one is talking about private pension, state private occupational, that one, and that's referred to as category E. So then, if you have money in your pension pot, you could use that, can't you?
Yes.
Okay.
So
Then
each of
the.
the categories, so you can see we have A, B, C, D, E, F, G. These are all categories. But most
Mhm,
of the time we rely on A and B,
A
which
and
is
B.
your salary from employment or profit from self-employment.
Okay.
But there are others you can rely on depending on your circumstance.
Right. So yes, meeting the financial requirement, we have gone through the categories.
And
Um,
before we jump from here, it just says that in exceptional circumstances, which we mentioned, if the person doesn't meet the requirement, then the application will be decided under Jan 3.1, 3.2, or under EX1 of the immigration rules.
Okay, and that's why we're saying other credible and reliable sources of income, financial support, or funds available to the couple may be taken into account under the minimum income requirement under paragraph 21A of Appendix FM-SC and
Very good.
in the exceptional circumstances page, which if you go on to .gov.uk, you could have access to. We are almost out of time, but yes, you may have a question, you may have a concern. As I mentioned, you can put them in the comment section down below on Facebook and YouTube at BWF Solicitors and at BWTV UK. And also, you can send that text to 0739920848 or call the number as well, 0739920848. So we were going to pick up the comments on the platform. So let's get to that quickly. Ankara, Julius Chumasi, I'm in skilled work. I'm on the skilled worker route. I guess that's what you want to say. How many days can I spend in Ghana with double entry?
I don't know what double entry is.
Hmm.
Because, I mean, if you're a skilled worker, you'll be given either 2 years, 3 years, or whatever you have, and you
Hmm.
can go and come. So it's not like double entry like visitors, but it's automatic that you can go and come. So your question is, how many days can I spend
Spend
in
outside
Ghana?
of the UK
You can
whilst
spend up
under
to
contract with somebody
up to 180 days.
up to 180 days.
Yes.
Okay, so Julius, yes, that's your answer. Thank you so very much. We have Theophilus Bitor. Do my spouse need to provide their fingerprint again and pay an amount of about £4,000 if she was giving years from Ghana? If so, what next?
The question is not complete. Okay,
Theophilus
so
says
maybe this person is talking about 3 years, was given 3 years from Ghana. As what? As a spouse? Is it Appendix FM spouse or skilled worker spouse? Which one? But if it's Appendix FM spouse, I'm not sure why they will be given 3 years. It's usually 2.5 years. So maybe they are talking about something else. I'm sure maybe nursing or something, skilled worker. Theo, can you please come again? But in any case, you still have to renew. And if you are going to renew, you pay another fee, immigration surcharge fee, and also the visa fee. You also have to go for your new fingerprint, depending.
Okay. Yes, the next one is Julia saying thank you very much. We have a voice note from one of our clients, friends, viewers, and customers. If we could get to that and listen, it would be in Ghanaian language, but when we are finished listening to that, I will give a summary and ask lawyer to help us with the answer.
Mapocho, your friend, Eddie, a woman by UK. It's every application, being no more no consents na a application Eddie Mukola and one by UK. But answer na every application, a fra being na a catch and a pede, a mufama no one application. Na ebe yani bank details any the pay slip bits 1 year and also edon kolan ba kroma hade na abatement na life into no on consent na nyama then you know obotum we claim mbofama na mbocho no pedem.
Let's get a quick sum of that. This lady is asking whether their partner can claim their children when she was making the application, sought the consent of the partner, and the partner said no. When you bring the children into this country, they're going to disturb my peace of mind and encroach on my space and all that. You found a means of getting the children in there, and now this partner is coming around to claim the children. Does the father have any right to make such a claim? Lawyer.
Right. So if it's obvious that the children belong to both of them, then he has parental right to access to the children or to have access to the children. If the two of them cannot agree the arrangement, the man can go to court to seek child arrangement order so that he can have access to the children. So I think the best thing is to have a conversation with the man. At least the man is not asking the children to be sent back. The man is saying, I want to have the children to live with me, or I don't think the man is claiming the children should live with him. Is that a point?
Well, she just mentioned, can the man claim the children?
Well, not necessarily. The man can seek to have access to the children,
The children, but not
but not
claim them.
claim them per se.
Yeah, I think the lady's concern is, I wanted your consent to bring them. Now I've brought them. You are here as well. You didn't give me the consent because you think it wasn't conducive at that time. So once I brought them, now you want to take advantage of that and enjoy the company of the children. So
Yeah,
she
well,
doesn't feel it's fair.
I mean, it is what it is. Then if that's the case, the man will also say, okay, all right, then take them back. I will go for them.
Oh, well,
I mean,
well,
so
as I said, probably the best advice is for them to have a conversation and agree on something. The middle point would help.
exactly.
Hmm. Well, Julius is saying that I want to go to Ghana twice next year. Can I spend 6 months and come back and go again?
Julius, you have to decide whether you live in the UK or you live abroad.
Hmm.
I mean, yes, maybe you've got accidental visa to stay in the UK. It's accidental because some of us sometimes we get a visa, but we are really not really ready to relocate. But because you are seeking to renew it with a view to maybe permanent residence, why don't you manage it to show that you are living in the UK more than living in Ghana? Okay.
Okay. Well, keep them coming through. We got a few more minutes to do that. But remember, I gave you a scenario and I wanted some answers to that. So if you could help me as well, it would be very much appreciated. But if you have a question or concern, you want to call in, we've got a few more minutes to handle the 0739920848. Send a text or WhatsApp to that, or you can leave your comments in the comment section below, either on Facebook or YouTube at BWF Solicitors and at BWTV UK. Do we have a caller on the line? Hello?
Oh,
Yes, good evening.
yes. My name is Frank. I've got a question to ask. I had my indefinite in the UK in 1996.
Okay.
So I've been living in the UK since 1996 on my indefinite leave to remain.
Okay.
And I left the UK and went back to Ghana somewhere 2020 October. I've been living in Ghana since 2020 October, but I do come here occasionally to just visit friends in the UK and go back to Ghana. So I've not had a continuous stay in the UK ever since I left the UK since 2020 October.
Did you have your indefinite leave before in that time, really?
Yes, I had my indefinite in 1996.
1996, okay.
Yeah, but this is the case. I left the UK to settle in Ghana somewhere 2020.
Okay.
And
whenever you come in, you are not giving any hindrances. You are allowed to come in and go.
Say again?
You are allowed to come in and go anytime after the 1996, isn't it?
Yeah. Well, since 1996, I've been living in the UK till 2020 October.
Okay.
Right.
So
but,
it's about
I
5 years ago you decided to kind of relocate to Ghana, right?
Yes.
But you come in and out.
Yeah, I come in and out, and anytime I come, I don't spend more than 3 months.
Okay, so what's the question?
I'm now back in the UK, but I want to apply for my British nationality. So
Okay,
I
Laura.
want to know whether it will be possible for me to apply.
Okay, Laura. This is our friend who since 2006, I guess. 2020 has been living in Ghana, comes in and goes out. Would it be, or would he qualify to apply for naturalization?
Right. Is he on the line, our friend?
Yes, he is.
Hello, sir.
Hello.
Good. How are you?
I'm good.
Awesome. In the last 5 years, how many days have you stayed away from the UK?
So in the last 5 years, since October 2020, I come every year or two, but anytime I come, I spend about 2 months and go back to Ghana.
Okay. What it means that it's better to work with your presence in the UK since your absence is more. So your presence in the UK is 2 months per 12 months and 5, so 60. So out of the 60, you've done 10, right?
Yes, well, I don't come every year anyway, because when I
So
left in 20,
it's even possible that out of the 60, you've done less than 10 months.
Yeah, I've done less than 10 months.
All right.
Since 2020.
Yeah, I mean, the rule is that if you're applying for naturalization, which is under Section 6 of the British Nationality Act, Schedule 1, it talks about absence from the UK. And in the last 5 years, up to the date of your application, you should not have been absent for more than 450 days. It appears that in the last 5 years, you've been absent for more than 450 days, isn't it?
Yes.
Yeah, they will refuse you. So if you want to, you have to come in, then spend more time, refresh the time for the next 5 years. Make sure that you manage it in a way so that within 5 years before you apply, you haven't been away for more than 450 days. And also in the last 1 year, the last 12 months in which you are making the application, it has to be 90 days, no more than 90 days. Okay?
Okay, so if I get you right, since I came to the UK now, I mean, my recent journey back to the UK was, let's say, 1st November 2025. That means I would have to remain in the UK till 2030. That is 5 years.
You have to
until I'm able to make the application. And even before I make the application, I shouldn't be absent from the UK for more than 450 days, and also not more than 30 days within 1 year to the application. Is that right?
90 days. 90 days within the last 1 year.
Okay. So if you have a children there, what if I have a children in the UK? You have a children in Ghana, in back home. How can you apply for them? Is there any way I can apply for them to be, British if I've got kids in Ghana?
Right. If you have kids in Ghana, you have indefinite leave to remain. You can apply for the children to join you as their parents. So you being the parent of those children. But again, we have to look at where the mother is. Where is the mother?
The father is in Ghana.
Yes, so that will be sole responsibility matter for the children. The mother is present in Ghana, the children will be okay according to the rules. Unless the mother is coming with the children, which will be easier. So if you so wish, in the interest of the children, you may consider for the mother to come as your spouse, together with the children as one family. And when they come in, the mother can be doing to and fro, but for the children to get in, then when you have gone through the process, or at least once they are in, their mother, by the time their mother is ready to apply for indefinite, they can also apply for indefinite whilst you are waiting to put in your naturalization after 5 years of restarting the clock.
So if because their mother doesn't want to be in the UK, so if I want to just bring the case to the UK because I want to apply for just the case to be in the UK.
Under paragraph 297 of Appendix FM, we look at sub paragraphs. We have sub paragraph talking about the children and the other parent. One, the other parent must be dead for you to be responsible alone. If the other parent is alive, then you have to show that you are the only parent making all decisions in the lives of those children, and that the mother has been irresponsible parent, and and it's not in the lives of the children. If not, you have to show that the children's lives are such that if they are not relocated from Ghana to the UK, they will die. But it appears to me that from the conversations you've had with us so far, the mother is not irresponsible, and it may be difficult for you to prove so responsibility.
Responsible, that's why I want to bring the case.
Come again? Hello?
I think what we would want you to do, if you so would agree, that find time and speak to BWF solicitors, because there may be peculiar situations within your circumstance that would have to be addressed separately. So I would advise that you pick up the number 0208 493 7340 and book an appointment and come and see. At least you can have a lengthier and a more coordinated discussion with the lawyers, or even lawyer Charles Asma, if you'd want to do that, so they can advise you better.
Yeah, thank you. That makes sense. So we'll make time and come and have a deeper conversation.
Okay, all right. Thank you very much. I think we would, if there's any other comment on the platform, we'll pick that one as a last one, then go back to my scenario where we will pick up our answers and draw the curtains down with a summary from lawyer Asma. Amaberese applied for a graduate route visa after a university degree. Application was refused. The Home Office alleged that they have information from her previous employers to show that she worked more than 20 hours during term time. Application was therefore refused under paragraph 9.8.3 of the immigration rules. So I'm asking, why did the Home Office refuse the application, although Amma had completed her studies and was applying for a new visa? Was it because a student visa did not allow her work more than 20 hours per week during term time? Was it because Amma needs a certificate of sponsorship before she can work for an employer? Or was it because Amma's visa was cancelled for working during term time? I will just show you my social media handles in a jiffy, and when we come back, I'll pick up your answers before we go over to lawyer Asma to help us with a good answer, and of course, a summary of what we have discussed this afternoon. It's still the community and the law, brought to you by BWF Solicitors. Welcome back, and thank you for sticking around. So let's see what answers you have for me. Ama Bebersa's situation. Applied for a graduate route visa after her university degree. She was refused. Hagar Bing says, yes, because a student visa did not allow her work more than 20 hours per week during term time. Hagar, thank you. Next we have, which other answer do we have? Let's see. Christian Opoku says, I'm visa was refused because she needed a certificate of sponsorship before she could work for an employer. The next one is from Moses. Moses thinks it's number one as well. Moses, thank you. Let's go to the next one. Susan Yabua thinks because Ama's visa was cancelled for working during term time. Yes, thank you. Yabua also thinks it's number three. We'll go on to the next one. Let's pick up another one and go over to Lawyer Asma for an answer. Benjamin Damoa says it's number one. Lawyer Asma, Ama Bibrese's situation. Why was the visa cancelled?
Yes,
Or
so
refused?
Amma was told not to be working more than 20 hours during term time, and it appeared that she did. And under paragraph 9.8.3 of the immigration rules, students who breach their study conditions and work more than 20 hours during term time will be penalized when they are moving on to, for example, settlement or any other future application. And so, on the basis of that, once Home Office got to know about it, the new application will be at issue. And the reason is that because her student visa did not allow her to work more than 20 hours per week during term time, and she did, she is at risk.
Amma is at risk, and the answer is number one, because she broke the rules and she went against the conditions of her immigration situation as a student. Well, thank you very much, Lawyer Asma. And with that, I will come back to you. And as you graciously helped us this afternoon to look at UK spousal visa applications, different ways of meeting the financial requirements. Tilly, yes, you said number one. I think you're correct this time. Lawyer, can we have a summary, please?
So, ladies and gentlemen, viewers and listeners, today we looked at different ways of meeting the financial requirement as a spouse, applying to enter the UK or applying to remain in the UK with your partner. We've already defined who a partner is. We've already looked at other requirements, and our focus is the finance. We looked at different categories, categories A up to category G. And they look at different sources of income from employment as an employee to profit as self-employed, earning income and getting profit, to savings as a saver, saving of 16 or more than above 16,000 for you or for your spouse or for both of you. We also talked about other combinations such as pensions and so on and so forth. And so the learning is that anytime you are applying, even if you don't have the employment income, you can focus on other categories of incomes that you can rely on. In each category of income, there are specific rules. The 6 months pattern is important. And so you have to check to see whether you fit or meet that before you can rely on that category of income. We specifically mentioned that if you apply to enter the UK as a spouse before the rules changed on 11th of April 2024, then you have to still show 18,600. However, if you came with your children, then you have to show that you meet for your children as well. Each child, the first child is 3,800 and each other child is 2,400. Now, if you came or you are now coming and you are applying to enter, you have to show income of 29,000 because the rules have changed. And with the 29,000, it is capped for all to cover all children, regardless of the number of children involved in your application. For self-employed, we tried that some people may be running limited liability companies. For those people, they can be directors. And as a director, you have to file self-assessment for yourself using Form P11D as a director. You cannot rely on the company's bank statement, the company's incomes to make an application for your spouse. Otherwise, your self-employment income should be a sole proprietorship business where you only registered with HMRC, you are given UTR, and you can file your self-assessment. Self-assessment should be for the tax year in question. For example, if you are making an application today and we are in November, this year is tax year 2025, ending 2026 next year. That means because we are not yet in 2026, you should be able to show tax returns for 2024, 2025 to support your application for the spouse. In this case, tax return for the last tax year, and the return should show that you filed your return, you have the specific tax calculated for you to pay, and you have to provide Form SA302 as tax evidence. The accountant must prepare the accounts based on which you filed the returns, and the accountant must also add a letter or report. And also you must provide your UTR from HMRC confirming that you were qualified to file self-assessment. Because the tax self-assessment computation was done based on your income for the year, you have to provide 1 year bank statement showing the income based on which you filed those tax returns. When you are filing a tax return, there are usually two sums there. We have income and expenses, and also the profit after expenses. For immigration purposes, you are using the profit, not the turnover, because the turnover is before expenses. And so even if you made a turnover of 30,000 and your expense is 30,000, your profit will be zero and you don't pay any tax. So it means your immigration income is zero. But because you need immigration income of 29,000, you have to show that after your expenses, you have profit of 29. So when you are making immigration application and you use the turnover instead of the profit, the application will be refused because turnover is not the same as profit. But if you're an employee, then you can use your gross salary and not your net salary. That is the difference between self-employed and employee or employed. So for the purposes of this conversation, we have looked at the policy guidance issued on 11th of March 2025 for Home Office staff for case working practices. And it is clear that if you're able to meet the requirement, financial requirement, and you are applying under 5-year route, you will be granted. However, if you don't meet the requirement, then where necessary, you will be able to apply under 10-year route based on EX1 of the immigration rules, paragraph EX1, or based on Gen 3.1, 3.2 of the immigration rules. Gen 3.1, 3.2 are those paragraphs that talk about exceptional circumstances and general provisions. This is what we had for today.
And on behalf of everybody that's been part of today's program, we want to say thank you very much to Lawyer Charles Asma for your kind time spent with us. And also to all of you out there who have stayed with us for over 2 hours, we want to say thank you so very much. You have been good company, and we want to have you back again same time next week for another edition of The Community and the Law. BWF Solicitors, thank you. And to Lawyer Charles Asma, once again, thank you so very much for your time and education. And to Shilankra Padmo Dodu and my indefatigable producer, Professor Adair, we want to say thank you for doing what you have done. My name is Ulrike Frimpong. Good evening.